Okay.
Go ahead.
All right, everyone, if you would please mute. If you have not already muted, just mute yourself so we can keep a lot of the background noise, out of the presentation. All right, again, my name is Carmen Miller. I was a public defender over in Tampa, which is where I became acclimated and introduced to the Baker Act. I had never heard of this before until I had that particular job and that career, but it was very eye-opening, to say the least. And this is where I gained a lot of my experience with the Baker Act, and you'll see why fairly shortly. But let's go ahead and dive into this presentation. Next slide, or a slide, maybe. All right, so what is the Baker Act and what happens in a Baker Act hearing? And although you may work in the mental health profession, you may not have ever attended a Baker Act hearing, or maybe you've signed an affidavit to have someone Baker Acted, but you didn't really know what happened to this person afterwards. So we're going to dive deep into the Baker Act and give you a lot of information. And for some of you, this may be a crash course in the Baker Act. It might be a refresher, as was stated before. And for some people, it might just be a lot of insightful information that you just did not know. So let's get to it. Next slide. All right, so what is the Baker Act? Well, in Florida, the law which covers all parts of mental health treatment is loosely termed the Baker Act, and we'll get on the next slide to let you know why. The Baker Act became the slang term for one part of this law, and that involves the involuntary psychiatric examination and commitment of persons. And the key word here is involuntary. So it's kind of like being arrested. People generally do not say, "Hey, officer, please arrest me." Instead, you are going against your will to have a psychiatric evaluation. Now, if you meet the criteria for a Baker Act, you can be taken away in handcuffs by law enforcement without your consent and held for up to 72 hours or more in a psychiatric institution. Now, a minor, thanks for the work that the CCHR has done, but a minor can be released after 12 hours. So that's a great win, so that the minors do not have to stay in that facility for 72 hours. But yeah, you'll be at the facility to determine if that person, and in fact, meets the criteria for the Baker Act and to be held further. And that further time could be a week, it could be months, it just doesn't matter. Well, it does, but we'll get to that later. Now, this presentation covers what the Baker Act is and how it affects Florida residents as a potential human rights violation. Next slide. Now, Baker Act, why? It's because in 1971, the Florida Mental Health Act was passed in our state legislature, and which brought a revision to Florida's almost 97-year-old mental health laws. Way back in the day, and we're talking about 1860s, a person could be just taken out of their home under not a Baker Act at the time, but for an involuntary examination with very little due process rights, very little victims' rights, very little patients' rights. But this legislator, Maxine Baker, and she was down south in Miami-Dade County, she really spearheaded this revision of the laws. And we have a quote from her that states, "In the name of mental health, we deprive them of their most precious possession, liberty." And that should really hit home for everyone. You can be taken without your consent to a facility that you don't want to be in, don't think that you should be in, and held as an adult for over, up to 72 hours. And that's kind of like being arrested, like I said before. Next slide. Now, what are the statistics on the Baker Act? And we've just been able to update this particular slide. For the first time in almost 20 years, there's actually been a reduction in Baker Acts, which is a great win, to help out people, in our communities. The most recent report on the number of Baker Acts shows that during the fiscal year of 2019 to 2020, there were 202,598 total involuntary examinations, and that includes 35,965 minors. And again, what should kind of hit home here is you have these kids, whether they're coming out of schools or off the street or maybe from a home where a parent is kind of thinking, I don't know what to do with my child, I cannot control my child, whatever. And these kids are being Baker acted. Next slide. Now, what does the law actually state? Now, we're going to look at Chapter 394, which is Florida's Mental Health Act. And for involuntary inpatient placement, the criteria that have to be met is that a person may be ordered for involuntary inpatient placement for treatment upon a finding of the court. So a court is going to get involved by clear and convincing evidence. And clear and convincing evidence is kind of a nebulous and vague type standard. It's not as high like a criminal case, like beyond and to the exclusion of all reasonable doubt, but it's not as low as a preponderance of the evidence. So essentially what that means is you have a magistrate who represents the court, general magistrate, who listens to the facts and testimony, takes in evidence, and if she believes that essentially more likely than not, a person needs to be confined for more care, then a person can be Baker acted. But again, there has to be these criteria met. And one of the major things of a Baker Act is that he or she, that patient, has a mental illness. And because of that mental illness, other criteria are met. Now, this is a huge stumbling block for how this Baker Act is effectuated and how it's executed. Who determines that a person has a mental illness? And if you really think about it, because a school can Baker act someone, a law enforcement officer can Baker act someone, a parent or aunt or whoever can Baker act someone, who is actually qualified to determine if you actually have a mental illness? Now let's go to the next slide. Okay, next. All right. So let's start off. Well, let's define mental illness. And for those of you who work in the psychology field, you'll understand that this definition of mental illness is not exactly what's in the DSM, the Diagnostics, Manual. But for the state of Florida, mental illness means an impairment of the mental or emotional processes that exercise conscious control of one's actions or of the ability to perceive or understand reality, which impairment substantially interferes with the person's ability to meet the ordinary demands of living. We're going to break that down as we go through our presentation, but essentially, this is someone who does not understand reality, could potentially be homicidal or suicidal. Maybe they're neglectful of themselves. That's part of the criteria for Baker Act. The term does not include a developmental disability. So we're looking at someone, the old term is retardation, but essentially someone who's autistic, intoxication. So someone who's drunk, substance abuse, someone who's on heroin or some other type of medication, legal or not, or conditions manifested by dementia. So, your grandma your mother-in-law, your father-in-law may be suffering from something like dementia or Alzheimer's disease. And in the old days, and by old days, I mean up to 2 years ago, they could be Baker acted, although this is a mental deterioration and not necessarily a mental illness. So dementia, traumatic brain injury. So just think of someone who maybe was in a car accident and, or had a shaken head and had a concussion and, the brain just isn't functioning as it used to. Again, up to 2 years ago, those types of people could have been Baker acted, although they have nothing to do with mental illness. It's a brain issue. Or antisocial behavior. Now that's a whole other can of worms we're not going to get into, but but when you're dealing with people who don't even relate to others in a positive way or in a helpful way, they cannot be Baker acted because it's not considered a mental illness under the state law. Next slide. All right, so let's get a little bit into more. So we're talking about someone who has a mental illness, and because of that mental illness, he or she has refused voluntary inpatient placement for treatment after sufficient and conscientious explanation and disclosure of the purpose of inpatient placement for treatment. So think about that. Essentially, if you have a mental illness and some nurse or doctor tries to explain to you that you should be at a facility voluntarily to receive treatment, and you say, no, I don't want that, your refusal can be used against you. And that should really bother everyone on this call. You can be a completely lucid person and say, I don't want to be here. And that can be used as a criterion to Baker Act you. So you can refuse to accept this type of treatment, or he or she is unable to determine for himself or herself whether inpatient placement is necessary. And in my experience, this has been used for people who basically they're drunk, or they have they're on some sort of MDMA or Molly's or whatever, and they just don't have the ability to decide whether they should be at the facility or not. And again, that should really bother you. Your refusal or your inability to decide that you are going to be at this treatment facility can be used against you. So you can refuse, or you can be unable to determine for yourself to stay at the facility. And next slide. And he or she is incapable of surviving alone. So this is that neglectful portion. Incapable of surviving alone or with the help of willing and responsible family or friends, including available alternative services, and without treatment is likely to suffer from neglect or refuse to care for himself or herself. And such neglect or refusal poses a real and present threat of substantial harm to his or her well-being. Now, to kind of break that apart a little bit, again, we're dealing with someone who has a mental illness, who cannot decide for himself or herself to be at the facility voluntarily, and is neglectful. And if you define neglectful, what does that really mean? And when does that neglect present a real and present danger? So are we talking about someone who isn't bathing or hasn't washed their hair, someone who is not paying their bills, regularly? They're not paying their Hulu bill, they're not paying their mortgage, etc. So neglectful is a bit of a nebulous standard again. And also part of this prong, this criterion for Baker Act, is that if you have someone who's willing to take you into their custody and help you with your meds and make sure you bathe, etc. That help from friends and family. Do you have that kind of support? And if you do have that kind of support, according to this portion of the Baker Act law, you should be released. And what I've told people repeatedly is that you should know someone's phone number and not just rely on your cell phone. We're all in that cell phone culture where you don't know your neighbor's phone number, but you just know, Becky or Tubula or whatever her name is. You just, you push that in your phone. But you should actually memorize someone's number who can come by and hopefully help you get out of a Baker Act situation. So you're going to have mental illness. You refuse or you're unable to decide for yourself to stay at a facility, or you're neglectful of yourself and your well-being, or next slide, or there's substantial likelihood that in the near future, he or she will inflict serious bodily harm on self or others, as evidenced by recent behavior causing, attempting, or threatening such harm. So this is that homicidal or suicidal prong to the Baker Act. And of course, this could mean someone who cuts themselves recently, someone who is taking a lot of pills, potentially. I did have a client once who he was wearing full camouflage gear and was walking down his street just shooting a gun in the air. And that was deemed to be, of course, homicidal behavior. He was facing, Florida has that 1020 life statute. So discharging a firearm in public is minimum 20 years. So he was facing multiple counts of 20 years, followed by 20 years, followed by 20 years, followed by 20 years. So I was able to get him Baker Acted because it seemed to me that he needed some acute psychological treatment instead of spending, multiple tens, decades in prison. But that helped him, and the state attorney agreed, which was very good for him. So you're homicidal or suicidal, and all available less restrictive treatment alternatives that would offer an opportunity for improvement of his or her condition have been judged to be inappropriate. And that's something to really consider. The question that I don't always get a satisfactory answer for is when I ask doctors or nurses at these hearings, Baker Act hearings, is what alternatives did you look at? Did you talk to CASA or Goodwill or the Spring or any other type of location where a person could be situated instead of being Baker Acted? So the way the statute is written in and of itself, Baker Act should be the last resort, not the first. Next slide. And I've kind of already talked about this, trying to break this all down, but just in other words, what is a Baker Act? When a person has a mental illness that causes the person to refuse to be convinced that voluntary placement is necessary and will neglect personal care or is likely to cause harm to self or others, and alternative placement is inappropriate. That's your Baker Act criteria. Now, what I have had multiple clients tell me is that a doctor or a nurse will actually tell them that if you do not sign voluntarily, you will be Baker Acted. I have not gotten a doctor or nurse to agree that that was what my client was told. But if you are in this situation, beware that you can get that type of ultimatum from a doctor or nurse. Next slide. All right, so who can Baker Act someone? And essentially, you're going to find anybody. A court can do it by an ex parte order. Ex parte just means the judge only hears one side. So you, as a potential Baker Act recipient, that's a best word to put there, you don't have the opportunity to defend yourself against a Baker Act. So my sister, my husband, my uh, neighbor across the street, they can go to a courtroom and fill out an affidavit saying, I think Carmen Miller should be Baker acted. She seems very depressed, or she seems very manic. Judge, please issue an order to Baker act her. So a judge, sight unseen, has not ever met me, has not made any personal conclusions at all, can issue an order to Baker act me. And unfortunately, that order is going to go to law enforcement. So we can look at Part A2. So law enforcement has the ability to effectuate that order. And if that means that they're going to break your window at your apartment or your house or kick in your door, they can do that because there's a court order. On the flip side of that, let's say a law enforcement officer comes in contact with someone who maybe supposedly shoplifted from Walmart or is sleeping on a park bench, whatever. The law enforcement officer himself can initiate a Baker Act without a court order. So that person may come into contact with law enforcement and still get put in the back of a patrol car and taken to a closest facility. Next group of people who can Baker Act someone is a physician, a clinical psychologist, a psychiatric nurse, an advanced practice registered nurse, an APRN, a mental health counselor, a marriage and family therapist, or a clinical social worker may execute a certificate stating that he or she has examined a person within the preceding 48 hours and find the Baker Act criteria to be met. So let's say you're going through marriage counseling, to fix your marriage or whatever. And if your counselor thinks that you meet the criteria, your counselor can fill out an affidavit and send it to the courthouse and have you Baker acted. Next slide. So what is this examination? And again, for kids, its limit is 12 hours, but for adults, it's 72. 72 hours to be examined by a psychiatrist, so someone who can, mental health professional who also can prescribe medications, and a psychologist or other psychiatrist. And this is where the ripple effect of who can Baker act someone just gets wider and wider and wider. A licensed physician who has postgraduate training and experience in diagnosis and treatment of mental illness, or by a psychiatric nurse or an advanced practice registered nurse. And if you look at it, a licensed physician, there's no statement in this law of how much experience this physician needs to have, or how much training, like should it be a semester, should it be a year, should it be 200 hours? That the law is just silent on that. The examination can be face-to-face, in person, or by electronic means. And 2 years ago, I would have kind of raised a fit about the electronic means. But now that COVID and the pandemic has hit, you can understand why this law was actually kind of ahead of its time. you can be examined by a psychological mental health professional by Zoom or FaceTime or Skype. So electronic means are acceptable. If this is not done, so if this examination is not done timely, the patient shall be released or be subject to voluntary outpatient treatment, or if a person is charged with a crime, they can then sign voluntarily. So you have the option, even if the 72-hour period is not met, or 12 hours for a minor, again, to basically say, you know what, I'm just going to let the Baker Act protocols just kind of, go by the wayside. Instead, I'll sign voluntarily. Next slide. All right, but there is a contradiction in the statute, and we just talked about 72 hours or 12-hour hold, but there's another portion of the statute that gives a lot more leeway, and that's also in 394, but a patient shall be examined by a physician or a clinical psychologist or by a psychiatric nurse performing within the framework of an established protocol with a psychiatrist at a facility without unnecessary delay to determine if the criteria for involuntary services are met. So without unnecessary delay is potentially more than 72 hours. And that's, again, something else to consider, that you might be there longer as a patient under this particular portion of the statute. Next slide. All right, now we're going to look at specifically minors. And K through 12, kindergarten through, senior in high school, under Florida Statute 1002.20, entitled K through 12 Student and Parent Rights, parents of public school students, so let's stop there. So we're not dealing with private school. Okay, we're dealing with public school. Public school students must receive accurate and timely information regarding their child's academic progress and must be informed of ways they can help their child to succeed in school. K through 12 students and their parents are afforded numerous statutory rights, including but not limited to the following. And specifically for a Baker Act, subsection 3. Health issues. Sub 1, notification of involuntary examinations. The public school principal or the principal's designee shall immediately notify the parent of a student who is removed from school, school transportation, or school-sponsored activity and taken to a receiving facility for an involuntary examination pursuant to Section 394.463. The principal or designee may delay notification for no more than 24 hours after the student is removed if the principal or designee deems the delay to be in the student's best interest, and if a report has been submitted to the Central Abuse Hotline pursuant to Chapter 39 based upon knowledge or suspicion of abuse, abandonment, or neglect. Now, to tear that apart a bit, essentially, if the school believes that your child is being abused, neglected, or abandoned, your child can be Baker Acted. And take a step back from that. No mental illness, no, learned conversation on why this child should be, at a facility. There's no proof that the child is neglecting himself. There's no proof that the child is, hurting others or hurting himself. It's just abuse, neglect, or abandonment. And that should really rock you to your core. Your child, whether, abuse allegations are actual and truthful, can have a Baker Act or a mental health history when there is no mental illness even being alleged. Next slide. Now, what are your student and parental rights? Before a principal or designee contacts a law enforcement officer, again, to effectuate the Baker Act, he or she must verify that de-escalation strategies have been utilized and outreach to a mobile response team has been initiated unless the principal or designee reasonably believes that any delay in removing the student will increase the likelihood of harm to the student or others. Now, this portion of the statute is very clearly targeted or meant to address children who are violent at school, especially with the rash of school shootings. Of course, you don't want to deal with too much de-escalation if someone is actively walking around the school and shooting people. But at the very least, the principal or designee is supposed to at least try to de-escalate a child's situation so that the child can calm down. Maybe the child just needs some quiet time. Maybe the child just needs to be away from a bully or something like that. We don't know. But go with those least restrictive or restrictive means and those other alternatives before going with the Baker Act. Now, the most troubling part of this statute is the next sentence. Next couple of sentences. This requirement, and again, to de-escalate, does not supersede the authority of a law enforcement officer to act under Chapter 394. So as you are maybe aware, at schools, they have student resource officers or school resource officers. And these are law enforcement officers who are at the school, all day long, and they get to know the students and know their friends and whatnot. And that officer can initiate a Baker Act without doing any type of de-escalation. The next sentence is that each district school board shall develop a policy and procedures for notification under this paragraph. Now, that is a bit alarming because if you consider how many school districts are in Florida, a student in Pinellas County might get treated very differently than a student in Duval or a student in Miami-Dade. So what this law actually sets up is sort of a quilt or patchwork of different policies and procedures that can go on throughout the entire state without any real rhyme or reason. So we're going to need to have a lot of data that comes in to see, are girls being treated differently than boys? Is there a socioeconomic standard here? Is there an age issue? When a kid is in puberty versus not, there can be a lot of factors that go into how schools treat students. And until we have more time to collect this data, then we just won't know if all the kids in the state of Florida are being treated fairly. Next slide. All right, so there's going to be some paperwork. So you have that examination that's going to be done. And the paperwork is that the receiving facility will file a petition for involuntary inpatient placement in probate court. So we're dealing with probate court, not criminal court, but probate. And probate generally deals with people who are incapacitated. They cannot make decisions on their own. So the assumption here is that if you're under a Baker Act, you can't not make decisions on your own. Just like someone who's, passed away and, died, they have a will potentially or not. Some people die without a will, but of course that person cannot make further decisions for themselves. A guardianship, again, let's go back to that traumatic brain injury. If you are concussed, you most likely you're not able to make decisions for yourself or think clearly. So that's really what probate court is about. Unfortunately, though, even though your case is going to end up in probate court, a lot of the Baker Act has some quasi-criminal elements to it. And we're going to get to that as we go through this presentation. The clerk of whatever circuit you're in will provide copies of that paperwork to the department, and that's the Department of Children and Families, the patient, the patient's guardian or representative, and the state attorney and public defender of the judicial circuit in which the patient is located. Now, in all of my years of dealing with Baker Act clients and having Baker Act hearings, I have never had a client actually show me their paperwork. So what typically happens is patients at these facilities, they get kind of like a shoebox, like a plastic shoebox, like a cubby, and that's where their property goes, and that's also where their paperwork goes. So typically these patients, my clients, don't even see their paperwork, don't even know what's written in their paperwork, do not know what they're being accused of doing in their paperwork because they don't actually receive their paperwork. Now, the paperwork is also supposed to go to the patient's guardian or representative. So who is that going to be? You know, if I went to a facility right now, who is supposed to be my guardian or representative? Would that be my husband? Would it be someone who I have a power of attorney or a mental health, advanced directive? And how would the facility even know who that person is to contact that person to even provide the paperwork? Those are more phone numbers and contact information that I'm going to have to know. So how often does that get effectuated? I'm going to say probably little to none. And as I stated before, my experience with the Baker Act, I gained as a public defender. And as you can see here in this portion of the statute, the state attorney and the public defender are involved. And if you did not know, state attorneys and public defenders, we deal with criminal acts. Why in the world are we in probate court? And the reason is, as a quote that was Miss Maxine Baker stated, is that someone's liberty is being taken away. So it's not a criminal context, but the public defender is automatically appointed to help these people get out of this situation. Next slide. So again, counsel, within one court working day after the filing of the petition for the involuntary inpatient placement, the court shall appoint the public defender. Now, that's within one court working day. So God forbid you get Baker Acted on a Friday. Saturdays and Sundays, those are weekends. Those aren't court working days. So you may not even receive an attorney until Monday morning. The state attorney for the circuit court in which the patient is located shall represent the state rather than the petitioning facility administrator as the real party and interest in the proceeding. So this statute effectively holds no liability to the receiving facility. So that psychiatrist, psychologist, the nurse, the APRN, whoever reviewed you and did that and wanted to have you committed is not the person who has to come to court necessarily and defend that decision to keep you at the facility. Instead, it's the state attorney. And this is a huge hurdle for civil attorneys to get around if someone has been wrongfully Baker Acted. Who do you sue? And under what theory do you sue? Next slide. When are you going to hold this hearing? So we've already talked about one court working day to even get an attorney, but now you have to deal with when to hold a Baker Act hearing. The court shall hold the hearing on involuntary inpatient placement within 5 court working days, unless a continuance is granted. So now you're dealing with 5 court working days. So let's say that you got Baker acted, some law enforcement officer took you to a receiving facility on Friday. You don't get an attorney till Monday, and then 5 court working days, potentially Friday, the following Friday, you can finally get a hearing. Now, when I was an assistant public defender, what we would do is we had certain facilities that we go to, St. Joseph's, the Memorial Hospital, etc. And we would go see our clients Monday because their hearing was set for Wednesday. And that's how we kept up with our clients. And of course, I had clients who would think, you know what, I'm happy here. I want to stay here. I don't want a Baker Act hearing. Fine. That's their choice. We have clients who would say, I want out. I don't need this to be, I don't want to be here. And okay, your hearing's Wednesday, and we're gonna, get on that to help you get out. And of course, there would be clients who no longer met the criteria and might be released Tuesday. So we would get to the facility on Wednesday for a hearing for someone who was already released from the facility. So, of course, we don't have that hearing. Unfortunately, though, a lot of our clients, our Baker Act clients, are kind of repeat customers. They might get out on Friday and be right back at a facility 2 weeks later. And that, again, is unfortunate, but it just kind of shows that they maybe needed more care than they actually received, or whoever is calling, the cops on them, or that school, principal or designee is Baker acting the wrong, minor. Okay. Now, the hearing is going to be held, if possible, in the county where the patient is held, typically at the receiving facility. So Baker Act hearings do not occur at the county courthouse. They occur at the receiving facility. And just to paint the picture for you, if you can imagine kind of a regular sized bedroom, you have a conference table there. You have your general magistrate sitting at the head of the table. I, as a defense attorney, would be on one side, sitting next to my client. Across the table from me would be the state attorney and whoever the state attorney's witness is. And that's it. There's no court reporter. There's no jury. This is just a bunch of people, 4 of us, kind of talking to each other. And I get to question that the state's witness. If my client wants to testify or speak up for herself, she gets to talk to the judge, and that's how the hearing is held. The hearing itself may be all of 10 to 15 minutes. It's not long at all. Next slide. So not that type of courtroom, okay? It's going to be, like I said, like a bedroom situation with a table. All right, so who are the witnesses? Well, one of the professionals who executed the petition for involuntary inpatient placement certificate shall be a witness. So that that marriage counselor, that psychologist, or whoever has to be a witness, but only one of them, not both, just one. The patient can have a no-cost independent examination, and this might result in a continuance. So let's say I've talked to my client and she's very adamant. I do not want to be here. I'm not manic depressive. I'm not, etc. I can move to have the hearing go past the 5 days. Of course, that results in my client being in the facility for longer than necessary, but have that hearing held off and have a third psychological professional come and evaluate my client. And maybe that's the tipping scale. Maybe there's 2 professionals at the facility who want my client to remain, but we have our own professional who says no. And that's going to be a different a different perspective to provide to the general magistrate and take into consideration as to whether my client needs to remain at the facility. The testimony in the hearing must be given under oath, and the proceedings must be recorded. So here we are in, again, this quasi-criminal territory where we're in probate court, but having your proceedings recorded and testimony given under oath, you're dealing with, Sixth Amendment and Fifth Amendment rights. The patient may refuse to testify at the hearing. So even in probate court, my client has a Fifth Amendment right not to talk if he or she does not want to. Another issue that the general magistrate is going to have to determine is, can the patient even consent to treatment? And unfortunately, what facilities do, they're called ETOs, emergency treatment orders. And essentially, if the facility believes that you are acting way out of order, or you're manic, you're angry or whatever, you can get a shot of Haldol in your hip. And that's meant to immediately calm you down. And I've had clients who've had these ETOs, again, emergency treatment orders, and they are sleepy, they're drooling, they are kind of comatose. And it's hard to talk to a client, of course, who is in that condition and does not know who I am, doesn't know where they are. They don't know why they are wherever they are, but they're under some very heavy medications. Next slide. Oh, let me stop. One conspicuous witness that is not mentioned is the person who actually called the cops or filled out the affidavit to have you Baker acted. So that law enforcement officer who may have come into contact with you while you were sleeping on a park bench, or that neighbor who called the cops to get you Baker acted, does not have to be at the hearing. So what that means is a lot of hearsay comes into these hearings. So what can the court order? This is, again, the general magistrate. The court can order your complete release. The court can say, you know what, you should never have been Baker acted at all. You're going to leave this facility. You're done. The court can say involuntary outpatient treatment. So maybe you get released, but the court's going to say, all right, report back to this facility Tuesday at 1:00 for therapy session. Involuntary inpatient placement for up to 180 days. So what could have started as, I don't know, some weird, like I said before, shoplifting event at Walmart could end up with your being placed for 6 months in a receiving facility. And I'm going to keep using the term receiving facility because not all hospitals are receiving facilities. There's North Tampa Behavioral Health. It's over off of Bruce B. Downs in Tampa. It's not a hospital at all, but it is a Baker Act receiving facility. The facility can keep petitioning the court for continued placement, and they can transfer you to a different facility. So you may have started out at, I don't know, All PEMS or All Children's Hospital or wherever your facility is, and get transferred to a different facility. Next slide. Now, what documents are needed for your continued placement? The documentation must include any advance directives made by the patient. And I'm going to stop there. Okay, what are advance directives? You might know this term as a living will, but essentially what it is, you being of a lucid, sober mind, fill out a document about how you want your body treated in the event that you are not of a lucid or sober mind. And that can be, again, get into a bad car accident, maybe you have dementia, there's certain things, life events that can happen. And there is something called a mental health advance directive, where you can specifically target psychotropic medications. So the documents that go for your placement, so any advance directives, a psychiatric evaluation of the patient, which of course would have already occurred, and any evaluations of the patient performed by a psychiatric nurse, a clinical psychologist, a marriage and family therapist, a mental health counselor, or a clinical social worker. So that group of people who can effectuate a Baker Act can still have a say in whether or not you are have continued placement and continued restrictions. Next slide. And I've kind of broken it down as we've gone, but this is how a Baker Act generally happens. Overwhelmingly, like criminal court, public defenders are in the trenches. It's difficult to get a private attorney to take on your case. Well, one, to find one, especially if you do not have anybody's phone numbers memorized, but to find a private attorney who can, just be available for Thursday at 2:00. So public defenders are really the ones who mete out this machine. All right. Clients, like I said before, some of them are comatose, they drooling, some are anxious, and they kind of tap their hands, or fingernails throughout the hearing. So it just kind of makes them look a little worse to the magistrate. And of course, inconsolable. They don't want to be there. They're crying throughout their hearing. And I have to tell my clients, I need you to hold it together for at least the next 20 minutes, because we're trying to put our best foot forward to get you out of here. And if you're acting oddly and crying and you're tapping your foot and you're whatnot, that doesn't make you look good. You got to follow the money. All right. Everyone is walking around with dollar signs over their heads. But when you deal with facilities who might need to keep at least 80% occupied, or pharmaceutical companies to get that Haldol in and that Xanax and whatever all else needs to be done, the billing to insurance companies, it's money. It's all money. And that's something that you need to consider. You're much better off, unfortunately, to not have insurance, because you'll be out of there pretty soon. But there are community-based facilities, county-run facilities. Mental Health Clinic, MHC, over in Tampa was one of them. PIMS is another one over here in Pinellas County. But yeah, you're a dollar sign. Somebody's making money off of your being at that facility. We have, of course, you have the same public defenders. You also have the same state attorneys. Over in Tampa, there was one state attorney who was assigned to the Baker Acts. So I would see him all the time, whenever I went to a hearing. You have the same psychologists, same psychiatrists, same nurses. It got to be somewhat rote in dealing with these facilities. It's Dr. Yeah, exactly. Yeah, they're all friends. Yeah, they're friends. They're buddies. In their cases where I'd have, if I saw a psychiatrist's name, I knew who signed off as the second examination. They kind of go in tandem with each other. So it was really somewhat eye-opening. It kind of made me wonder, of course, is this really accurate? Is this very truthful? Is this valid? Or is it just, hey, Rick, I saw that you did an examination. I'll sign off on it. And it was, just how you can see people get railroaded. And this is why this Baker Act can really be utilized as a human rights evaluation, because you have the state attorneys, the judges, law enforcement, public school administrators are all, in a way, cahoots. They're in cahoots with each other to effectuate the Baker Act, potentially as an abuse of power or a misuse of the statute. And you also have well-meaning people. So let's say, my husband wanted to Baker Act me because he thinks I'm acting oddly, or my neighbor across the street. They don't even know that they're misusing this statute. But for those of you who are in the know and you know how this is being used, then you can really um, retaliate against someone, and you can weaponize the Baker Act. Like I said before, there's no jury, there's no court reporter, and there's lots of hearsay. And the hearings I would have been involved in, basically you have a general magistrate who pulls out her phone or potentially a digital recorder and just, hits record. And that's it. That's your record for this hearing. Next slide. Now, there are a bunch of collateral consequences. As much as these records and these hearings are supposed to be confidential, how confidential are they really? I've had clients who were Baker acted, and then they receive a letter from the sheriff saying, hey, we need you to give up your firearm. So your ability to possess or own a firearm can be, affected. Of course, public defenders and state attorneys have access to these records because we get, appointed. And in a way, they're very helpful. Like I said, I had the guy in the camouflage who was just walking down the street and shooting in the air. Knowing his history is how I got him out of almost 200 years of prison time. This can be very helpful for mitigation if you have a mental health history, to kind of explain that maybe you were insane, or that type of thing at the time a crime was committed. So they can be helpful, but as you'll see down the list, not so much. They're taking away your gun. Medication registries. If you are taking medications and you're on clonazepam and trazodone, Depakote, Seroquel, even when you go to refill your prescriptions, a pharmacist who knows what they're doing is going to be able to tell exactly what's wrong with you, just based upon the medications that you're taking. And if you are on certain types of medications, doctors have to report these things to the state of Florida. So it's not a secret, basically. Just not a secret. There's also general public stigma. In recent years, you've had some celebrities who have either committed suicide or they've come out with their mental health truths. They go into rehab, they're whatever they're doing. And in a way, the silver lining, of course, with that is it's highlighting that it's okay to reach out for help if you need help. But in the larger scheme of things, this stigma still is around. So imagine if you are being handcuffed in your driveway, what neighbors are looking at you. If you're getting, the zip ties, as a minor, being carted off from school, what are the other kids saying about you? So it's not really, again, it's not a secret, but it can also be very humiliating. And that goes into your self-esteem and your self-worth. Do you really want your nickname to be at school to be Crazy Carmen? Or the neighbors are whispering about you behind your back. So it can really have a devastating and traumatic effect on you. And you possibly can have a negative experience with law enforcement. Imagine if your first experience with, a law enforcement officer is being, zip tied and put in the back of a patrol car. Okay, you're not going to be fingerprinted. You're not going to have your mug shot taken, but you're still in the back of a patrol car. That's not going to be a good feeling, especially if you're under the belief that you shouldn't be here at all. And this is just wrong. You should not be under this Baker Act situation. Next slide. Now, there have been some major media articles dealing with Florida specifically. This one is from, it was entitled Committed, Florida's Children Victims of Dysfunctional Baker Act System. The number of children who are taken for involuntary psychiatric evaluations in Florida increases every year. But we gave you some statistics earlier, so it's good that it's going down. This is the first story in a 5-part series about how the state's Baker Act affects children. And there's a very famous story that was televised and reported in national magazines and newspapers. And this kid, Nadia, she was 6 years old, and she was Baker Acted. And her mother is quoted as saying, "Mommy, I want to go home. Mommy, I want to go home." And just imagine how heartbreaking that is for a parent to hear. But this mother would not be able to see Nadia for 2 days. So she was held, Nadia was held and kept away from her parent in the state of Florida. Nadia's story reverberated around the country or county. It made Time Magazine, the New York Times, the Washington Post, state and local media as well. But Nadia is just one child. We have over 36,000 children are Baker Acted every year. And as I stated before, we need a lot more data to know which children are being Baker Acted. And again, is it more girls than boys? Is it people under the age of 10? Is it certain counties that are Baker Acting schools that are children at a higher rate? Things like that. Next slide. And to continue with Nadia's story, and there's her picture, a 6-year-old was held without parental consent under a law that allows for involuntary examination of minors. And there's the web address for that article. The decision to admit her under the Baker Act was made by a licensed mental health care professional employed by a private nonprofit community behavioral health care organization. And that's a quote from the Duval County School District. And when I read this quote, it just makes me think that they're just trying to play hot potato. It's not our fault she was Baker Acted. There was a mental health professional that was involved. But at the end of the day, who called that mental health professional? Next slide. This involves another media article, but of an older child. His name was Solon Caskey, and he was Baker Acted twice and released as soon as his care was reviewed. And that's another piece of data we need to know. If someone is being taken to a facility, how many people are actually held under a Baker Act? How many people get released immediately, or they're only held for maybe 2 or 3 hours? And that should be very clear proof that people are getting wrongfully Baker Acted. If a psychiatrist or psychologist, from the get-go, doesn't even think this person should be at the facility, then here we go. Why is this school or this parent or neighbor or wife or other family member trying to Baker Act someone who clearly does not meet the criteria? So he was Baker Acted twice and released as soon as his care was reviewed. And here's a quote. They want to use, this is from his mother, I believe, they want to use the Baker Act for any behavioral problem, anything they don't like. And that's from Hillary Caskey. If you have any kind of outburst, if you have any kind of emotion whatsoever, and you are not just an order following automation, they will Baker Act you. And I do believe that there are teachers and who just use the Baker Act to kind of get rid of problem students. So maybe this student is a behavioral issue, or I don't know, is talking out of turn in class or interrupting the class, things like that. And next thing you know, this child's being carted off. And it just shows again the misuse and the weaponization of the Baker Act. Next slide. Now, we're going to go through several slides that deal with the school safety bill. And of course, you can tell that this has a lot to do with school shootings. But of course, we're also trying to help kids and not, help them not be wrongfully Baker Acted. The bill requires public and charter schools to make a reasonable attempt to notify the parents of a minor student before the student is removed from school transportation, or a school-sponsored activity for an involuntary mental health examination. Now, as you can see, this bill went into effect July 1st, 2021. So it's basically a year old. And I can tell you, before July 1st, 2021, this was not the law. So imagine going to school to pick up your third grader, or you're at home and you expect your fourth grader to walk through the door around 3:20 p.m. and your child's not at school. Your child is not home at 4:35 or whatever time you expect the child to be present. And just imagine that the school has carted your child off under a Baker Act and you just do not know. And how frightening that is for a parent. Now, the bill defines a reasonable attempt to notify as the exercise of reasonable diligence and care by the principal or designee to make contact with the student's parent, guardian, or other known emergency contact whom the student's parent or guardian has authorized to receive notification of an involuntary examination. So at the beginning of the school year, when you parents are filling out your emergency contact, please just don't list yourself. Try to expand that, because you may be at work, you could be at Walmart or whatever, you're just not looking at your phone. Just try to make sure you have a plan B and a plan C, that someone else is, kind of waiting in line to get information about your child. Next slide. The bill requires the principal or designee to, at a minimum, use available methods of communication to notify a parent, guardian, or other known emergency contact following the decision to Baker Act a student. The methods of communication should include, but are not limited to, telephone calls, text messages, emails, and voicemails. Now, again, this is a huge change. This was not what the law was before. So the parents are getting an added layer of protection. And in a perfect world, you as a parent should be able to know that the school is even intending to do this, so that you can maybe diffuse a situation on your own. So it'd be great if the teacher would say, even by text or voicemail, hey, little Johnny needs to be Baker Acted. I can't control him or whatever. Well, I'm his mom. I want first dibs. I'm coming to the school right now, and just hold him there. And that way you can talk to your son and just be like, hey, what's going on here? Or what happened in class, whatever. And that should be one of the first least restrictive alternatives that can go on after the de-escalation or the mental health facility or professional is called, just to help out. But yeah, I would imagine as a parent, a guardian, baby daddy, whatever you want to call this person, would want to get involved early, so that trauma of the Baker Act does not occur. So requires the principal or designee to document the method and number of attempts made to contact the student's parent, guardian, or other known emergency contact, and the outcome of each attempt, allowing a delay of notification if it is necessary. Again, that's a child abuse hotline, to avoid jeopardizing the health and safety of the student. Now, again, a huge change. The bill is now defining what a reasonable contact is and requiring the school to document what types of attempts that they made to contact the child's parent. Next slide. Now, the law goes on to say that it mandates the collection of data by school districts and the Department of Children and Families, DCF, relating to the number and frequency of involuntary examinations of minors initiated by schools at specified school locations or events. So as I was stating before, yeah, you need this data. You need to know if Hillsborough is treating children differently than Pensacola. You need to know that, so that if other measures need to be taken, like by the legislature or people like me, attorneys, so we know who to sue, we know what we're going after. But if we don't have the data, and again, this statute is fairly new, it's going to probably take a couple of years so we can even get data, reliable data. And what's really good is the next section of this bill. The bill requires each district school board to adopt a policy mandating that the school superintendent annually report to the DCF the number of involuntary examinations initiated at a school, on school transportation, or in a school-sponsored activity. So now you're holding these school superintendents accountable for their school district, and not just let these school districts just kind of run haywire. The superintendent now is going to be called to the carpet as well. Next slide. The bill also requires all school safety officers to undergo crisis intervention training. Well, huzzah. Those student resource officers that are hanging around at the schools and walking the halls and whatnot, they need to undergo crisis intervention training. So maybe they can help with the de-escalation if a student is getting a little rowdy. The bill also requires school districts to adopt procedures mandating attempts at de-escalation to be made prior to initiating a Baker Act. So again, these schools are being held more accountable. And the hope is that these schools and the principals, the designee, the teachers, janitor, whatever, are not just randomly Baker Acting children because they are behavioral issues. Next slide. Now, the bill also requires schools to contact a healthcare practitioner capable of initiating a Baker Act in person or via telehealth. So again, we're getting that electronic means, telehealth, prior to a Baker Act being initiated. So we have all these layers that are going into a child being Baker Acted from school. The school itself needs to de-escalate. The school itself needs to involve itself in crisis intervention training. The student resource officer needs to involve himself in student, in crisis intervention, and contacting the parent. So maybe the parent or guardian or, other emergency contact can take, not possession, but take custody of that child. The mental health professional may be available to a school district either by contracts or interagency agreements with the local community behavioral health provider, a managing entity, or a local mobile response team. So essentially what this is saying is this person, this mental health professional, does not have to be, sorry, there's a cat here. But this mental health professional does not have to be an employee of the school or the school district, but could be. And that's what the next sentence is. Alternatively, the mental health professionals may be a direct or contracted employee of the school district. So we're dealing more with liability. That's what this bill is getting at, is who's going to be responsible for that decision to Baker Act a child. And next slide. All right, so now that was the school Bill of Rights, the student Bill of Rights. So now let's look at the parental Bill of Rights. Now in Florida, the state, any of its political subdivisions, any other governmental entity, or any other institution may not infringe on the fundamental rights of a parent to direct the upbringing, education, health care, and mental health of his or her minor child without demonstrating that such action is reasonable and necessary to achieve a compelling state interest, and that such action is narrowly tailored and is not otherwise served by a less restrictive means. So the legislature has decided to put in writing that parents control, okay? Parents control, and the school, a law enforcement officer, a state hospital, whatever, do not get to just step in place of a parent and his or her decisions regarding the upbringing of their child. Next slide. Now, there have been some more changes that have taken effect in 2022. So we're dealing with brand new stuff here. All right, so parental rights. Strengthen a parent's right to direct the mental health of their child. Require reporting to the parent by the school on perceived mental health issues. Require the school to refer a child to their parents instead of handling any perceived mental health issues. Prohibit schools from adopting policies or forms that prevent parent notification of mental health issues, and requires parental consent for wellness questionnaires and covert mental health screening. So I do think that this kind of touches upon, transgender and sectional, issues. But the goal here is to deal with mental health and keep parents as informed as possible to understand what's going on with their children. And unfortunately, especially if you're a parent who, has a job and you work, your teachers might be in more contact and spend more time with your child than you do outside of weekends. So your teachers, your children's teachers may have a little more insight into how your son or daughter, acts, on a day-to-day basis. Next slide. And here's some more changes, at least regarding the Baker Act. Increased reporting requirements on the Baker Act. Protect a patient's ability to communicate freely and privately with individuals outside of a psychiatric ward. And I'll stop there. These receiving facilities, it's not like a regular hospital where you can just have visitors somewhat any old time. Visitations might be Wednesdays from 6 to 8. And that's where a person may be limited. So if you did get Baker Acted Friday or Thursday, you may not even be eligible to receive a visitor until Wednesday. Now, as an attorney, I, of course, can see my client anytime I want. And when I would, see clients, I would ask them, is there anyone you need me to contact for you? And they might get a name. But again, a lot of people don't have phone numbers. So that's great that I know your sister's name, but I don't have a way to track her down, to even contact her to know, where she is, can she visit you Wednesday, etc. All right, and make changes to the law which would increase the required notification of a patient's whereabouts. So because of HIPAA, you can't just call PIMS or St. Joe's or whatever hospital or facility to find out if your cousin is there or your husband is there. The facilities are not supposed to give out that type of information. And in a perfect world, they will not give out that type of information, again, due to HIPAA. But if you were supposed to meet your husband for dinner, or meet a friend after work for drinks, all you would know is that your spouse or your friend never showed up. You don't really have a way to track them down if they were Baker active, so you can be in a position to help them. The expansion of individuals who may authorize the release of a person being held under a Baker Act. So not just psychologists and that marriage family therapist or a ruling by the general magistrate. Again, we're looking at the least restrictive means. So if I, as a spouse, or I want to get my neighbor across the street, get them out, I want to have the ability to do that. So again, least restrictive means. If this person can be released, and pharmaceutical companies and these receiving facilities, of course, they're all going to get hit in the pocketbook because the beds aren't filled.
Excuse me, Carmen.
Yes.
The Wi-Fi or something bleeped out for just a second, so you froze.
Okay.
Would you mind going back a few sentences and just repeat that, please?
Okay. What I just read was the expansion of individuals who may authorize the release of a person being held under a Baker Act. So it's giving some power to the people, essentially. So if I want to get my husband out, get my neighbor across the street out, I want to be able to do that. And these new changes to the law are going to expand who can get someone out, pick that person up from the receiving facility, sign whatever piece of paperwork that acknowledges that they're going to take a person into custody, or I'll make sure that my husband takes his medications or whatever, or I'll make sure that my husband gets to therapy. What day is it? Okay, Friday at 3. Okay, I will make sure he's here. Those kinds of things. So you have the ability under this particular portion of these additional changes that just came into effect, less than a week ago. But yeah, you have the ability to get someone out of the Baker Act. And what I was saying earlier is that this is really going to affect pharmaceutical companies, hospitals, receiving facilities, because those beds will not be filled. The doctors, insurance companies, because you can't get paid if you don't have a patient. So this expansion to allow for a greater opportunity for people to get out and leave the facility is pretty powerful. Next, the additional changes are to the language on what is to occur if the release happens on a weekend or holiday. And that could prevent psychiatric wards from holding people longer than legally allowed. And we mentioned this earlier. The way the statute, Chapter 394, is written is that within one court working day, you get a public defender, you get an attorney. Within 5 court working days, now you get, a hearing. And as I stated earlier, there are facilities that only hold their hearings on particular days of the week. So if you don't happen to fall within that Tuesday or Thursday, then you're going to have to wait. And until we have enough people who challenge that in court to say, hey, I'm being held here illegally, I should have been, let go Monday or Tuesday or whatever the date may be. If we don't have these people who are willing to stand up and be these test cases in court, then it's going to keep going on. And because you can't really sue the receiving facility, because again, the state attorney is the one who's that real party in interest by statute. Who are you going to sue? How are you going to sue? How do you get these facilities to stop disobeying the law if you can't hold them accountable, like personally? Last of the changes on this slide is changes to the law, which would include penalties. And maybe the next slide will show this, but if you wrongfully Baker Act someone, you actually can commit a crime. And here it is. Unlawful activities related to examination and treatment, and these are your penalties. A person may not knowingly and willfully furnish false information for the purpose of obtaining emergency or other involuntary admission of another. And what I can tell you is I primarily work in family law. Now I still do kind of Baker Acts on the side, but you'd be surprised at how many spouses or, baby mamas, baby daddies will use the Baker Act to get someone basically out of the picture, or give them a mental health history so that they can utilize that against the person for purposes of their family law case. It's quite ridiculous. But it's good that we have this law now in place where the persons who are weaponizing the Baker Act can be held accountable. Next, if you cause or otherwise secure or conspire with or assist another to cause or secure any emergency or other involuntary procedure in another person under false pretenses. So not only can you not do this on your own, you can't help somebody else to Baker Act someone, knowingly and falsely. And you cannot cause or conspire with or assist another to cause, without lawful justification, the denial to any person of any right accorded pursuant to this chapter. So, this again is, it's not chapter 394, because that's the Baker Act law and mental health law itself, but essentially you cannot basically deprive someone of their rights under the Baker Act. So this, in my mind, this touches on these nurses and doctors who say things to my clients like, if you don't sign, we will Baker Act you. That's where we're getting at here, because you have a right, an absolute right, to say, you know what, I refuse this treatment because I don't think I need it. That's your right. You have that it's your body. It's where you are. They would have to Baker Act you, or you get to, leave on your own volition, or you can be released AMA against medical advice. But yeah, you have an absolute right because it is your body. A person who violates this subsection commits a misdemeanor of the first degree and has to pay a fine. Now, a misdemeanor of the first degree is punishable up to 364 days in jail. So depending on, I guess, how egregious the judge, be a criminal court judge, county court, because it's not a felony, the judge can sentence you to 364 days in jail, or 180, or 10, or place you on probation. But the maximum is going to be 364 days. Next slide. Oh, here we go. All right. We've ended our PowerPoint presentation. We hope you've enjoyed it. We hope we've taught you something. And if you already were involved in the Baker Act situation, maybe you've learned something new if you've never been to a hearing before. And our biggest goal is to educate you so that you know if you're going to call the police or fill out an affidavit and send it to a judge, that you know what you're setting someone up for. We have a lot of resources. CCHRFlorida.org is a website you can go to. If you have kids and you would hopefully not have them get Baker Acted from school, there's a printable and downloadable form that you can file with the school that says, hey, don't Baker Act my kid. Love, Carmen Miller, so you have these resources. There are lots of videos on psychotropic medications and various aspects of the Baker Act and mental health that you can visit. If you can get to Clearwater, South Fort Harrison is where CCHR is located, and you can walk through. It's a whole museum that talks about and educates you further on the history of psychology and even touches upon Hitler and electroshock therapy, and just the history and how it's been weaponized and utilized and how it's been misused and abused. So educate yourself. If you can, get to Clearwater, visit the museum. Go on that CCHRFlorida.org, that website, get some more information and that downloadable form for your kids. There's also a mental health advanced directive that you can download and fill out. Just have it signed and notarized. And also, please, please, please memorize someone's phone number just in case you ever need it. And at this point, any questions? Any comments?
Yeah, there was a few questions that came through, Carmen, just so
Okay.
you know. And Carmen, before we go into those questions, I just want to say thank you so much for that legal overview on the Baker Act and the involuntary mental health law in the state of Florida. You are just a courageous human rights advocate, and we so very appreciate your help. Thank you.
Thank you. Yeah, no problem.
Definitely. So the few questions that I remember reading off the top of my head are, somebody wanted to know the difference between the Marchman Act and the Baker Act. And I don't know if the person heard me right now, but if you want to say something to Carmen yourself, please, by all means, take yourself off mute and go ahead. But that was a question. Yeah.
Okay. All right. So yeah,
yes,
the Marchman Act.
Can you hear me?
Yes.
Yeah, I'm the one that put it. My name is Patricia. I live in Pensacola. The reason I was asking is because I wondered, with everything you're talking about as a Baker Act, I had been on the other side of things with one of my daughters had to have, I initiated a Marchman Act, and what I went through as the person that was the petitioner was very stressful and really difficult. All I could say is it was difficult. So I just wondered, are there any changes to the Marchman Act that you know about?
Right. I'm not fully, I focus on the Baker Act, not the Marchman. But for those of you who are not aware, Marchman Act deals with people who have substance abuse problems or alcohol problems. And it's a way to intervene very acutely and forcefully, I might add, into their lives to try to get them into some sort of rehabilitation facility and some treatment. So it works a lot like the Baker Act, except the Baker Act deals with mental health. Now, of course, people, you can have a mental health issue that results in a substance abuse issue. Many people, especially like bipolar or being, depression, a lot of people self-medicate on that. And so they end up kind of falling into alcoholism, or they're using, street drugs and whatnot, or they have medications that they overuse. So they kind of go hand in hand, Marchman and Baker Acts, but you, of course, can have one without the other.
Yeah. One of the things that when you were describing the Baker Act hearings, it was the same way. We went into a receiving facility, and even though she wasn't there, went into a room where there's, lots of professionals, and, just feeling like, okay, I'm here again, and they would just continue it. And then there would be other family members of other people I didn't even know that would be telling me things going on in their lives. And I'm like, okay, we need a support group for each other,
right.
Because a lot of it has to do with access to treatment. And I mentioned that in one of my comments too, is that
Right.
sometimes escalates problems that could have been prevented.
Yeah, and that's why, like I said before about the stigma, and if you are feeling bad or you're feeling low and whatnot, if you don't feel that you can reach out to someone and get that support, and sometimes you don't have insurance, so you can't even really go talk to a psychiatrist or psychologist because it's $200 a visit, and it just doesn't, financially, it just doesn't work. But hopefully people have a friend. Talk to your mom, those kind, maybe there's a cheaper, alternative, but yeah, if you can't reach out and you don't have anyone to support you, you can very easily, get trapped into, alcohol abuse and substance abuse and all kinds of things, and just be terrible. And it affects your family. And if you have children and, is mom drunk again tonight? You gotta, it's gonna have that spillover effect.
Thank you so much, Carmen, for that. Thank you. And I don't know if everyone is going to stay on for that much longer while we have questions, just in case anyone's going to jump off. We did put the form up, the questionnaire. So if you could please fill out that form before you leave us today, CCHR Florida would greatly appreciate that.
Yeah, let me know what I can improve upon. Did I talk too fast? I mean, I don't know. You want more pictures? Whatever. I don't know. Just let us know.
Oh, you were perfect. You did great.
Thank you.
Yeah. And there were a couple more questions. I wrote down one more, but if anybody wants to take themselves off mute and ask this beautiful attorney and courageous human rights advocate any questions, please do so.
Shamika, I believe you have a question.
Yes, I love what you guys do, and I feel like you're going to help me a lot through I went through abuse at home as well as in these facilities. I go live when I'm at new facilities. I don't know if that's the right thing to do, but I go live, and I just went viral on one facility in Alabama. I don't play no games. You ain't finna play with my body, my life, or my mind. I'm outspoken for a reason because I've been abused. This is my, if you count how many times I've been actually under a Baker Act or a court order from being me, it'll give me 6 times.
Mm-hmm.
Wow. Wow.
I became
It's great that you speak up, because a lot of people they're humiliated, they're in shame, they don't want to, and even to have a client who's willing to go up against a facility. A lot of people just want to put this experience behind them, and they don't want to fight it. So that's why you have to have a test case. So it sounds like you said Alabama, but yeah,
no, I got it in Florida. I got it.
Oh, Florida?
I got
Okay.
3 times in Florida. Hold on, let me see. It might be 4. West Alabama, Baptist Health twice, Birmingham, Alabama twice. And I just came out of a facility again. This is not just, it's doctors doing this, family members doing this to me. Nobody can take my kids away from me because I'm a wonderful mother. And my mother, I lost everything, basically. I lost my job because I go in and tell them, hey, I have sleep insomnia because I'm living with a man that stressed me out so bad that I can't sleep. I learned that he's my trigger, so I moved on. But now he's trying to take my child from me. So I do need legal reputation because he goes to the cops with my medical records, violating my HIPAA rights.
Yeah.
And yes, violate my HIPAA rights, and the cops go for it and they lie and say I'll try to kill my daughter. And I got proof. And I also called the EAP, the Employee Assistance Program, because they messed up because I worked not a health group. I worked for them and they weren't about to bill my insurance and think it's okay because they ain't have prior authorization. Because that's what I do for a living. I file claims. That's what they messed up at. Because you ain't gonna bill me and say I got 0 copay, but you making my company pay $1,500.
Wow.
And they
I've had a client who was Baker acted. He got, I think, 90 something days, and of course you've experienced it. If you're going to be locked up for 90 days, your rent isn't being paid. You aren't not going exactly.
But they don't want to do that for me. They don't want to help me get no short-term disability, no EBT, no nothing like that, because they know there's nothing wrong with me. I got a nice personality. I love everybody, and I'll fight you if you try to come for my kids. So that's what I'm telling you. You got to be. I'm telling you, I need your attorney.
Understood.
My HIPAA rights have been violated because this man lied and said he was my husband, and he spoke for me when he didn't supposed to speak to me.
Wow. Well, it's great that you're connected to CCHR Florida now. Thank you so much. And
thank you.
Sir Carmen
every meeting I'll be here.
All right. Awesome. Right. Okay, perfect. There you go. And Samuel over there at CCHR Florida, thank you so very much for hosting this webinar for us. We had something come in on the chat, which is, please, can you send the slides for the presentation? Yeah. So that people can read their
sure.
Yeah.
That's great. I'm going to share the slide right now in the chat so that everyone can see it.
Good.
I'm going to send it newly. And then I did have a question that I wanted to ask on behalf of anybody else that might think this. Carmen, what do you think of the Baker Act in terms of, do you think it is needed sometimes to Baker Act individuals? Because you've gone over very specific points of abuse, which obviously is where we're coming from with this webinar. But what about the need of Baker? Like, can you talk on this?
That example I gave earlier, when I had that 1020 life client. He was facing 200 years in prison when really what he needed was help. He needed someone to talk to. And I don't know if he, is on pills or whatever. I just don't know. But I don't think that the Baker Act in and of itself is terrible. It's kind of like the Marchman Act. Some people just need some acute treatment. But when it gets weaponized, when it's misused, I remember I had a client, he got Baker acted. His neighbor was a Tampa Police Department officer who did not like his loud music. So now you have someone with the color of authority and Baker acting somebody. And of course, he makes a phone call and you just get one of your buddies, to come by and that guy, that neighbor, my client was going off to a facility. So it's helpful in the right situations. It's helpful if it's being used as it was intended. But unfortunately, the way it's written, it can really, you can drive, a van through these holes in some of these, the way that the statute is written. So it can be used, misused, abused, etc. But if it's used as intended, it can be helpful. And it should not be done all the time. And like I said before, I wish these facilities would look at these alternative resources.
Mm-hmm.
So maybe someone can, if someone's, domestic violence victim, then, don't Baker act her because she's weird, or crying all the time. Send her to the spring or CASA. If someone's homeless, and that's Goodwill or the Salvation Army. And a point that I did not make earlier is that when these people come into the Baker Act facility, it's not like they are getting full clinical screenings of what's going on in their bodies. So if I were to get Haldol, how does this facility even know if I'm allergic to Haldol or not? Or maybe I have some, unchecked urinary tract infection, and that's why I'm hallucinating. So these facilities, when you enter, they might take your blood pressure and check on your heart, but they're not going to look into how your liver metabolizes, medications or food or whatever. Or do you have allergies? So things like that. So so that's a point I did not make earlier, but it just lets you know that these are receiving facilities. They're not hospitals. You can get drugged and have a terrible reaction to it.
Mm-hmm.
So, and now you just look crazy or crazier or whatever. And It's not fair at all. But if they had taken the time to really look at you and explore not your body, but check your liver, make sure allergies and things like that. You don't want someone with latex gloves coming at you. If you're allergic to latex, because next thing you know, you're running around the room and saying hell no. Now you look crazy. You're not crazy. You just don't want to have an allergic reaction and pass out.
That makes sense.
So that's where I'm going with it. I'm
Thank
rambling,
you.
but yeah, I'm going.
No, you're perfect. Thank you so much for that, Carmen. Thank you. Well, so you guys, are there any more questions, or are we going to sign off for the day? I don't know. I don't hear any more questions. So thank you so much for joining us. We do appreciate you, and we'll so appreciate your help in reforming the area of mental health, right, Carmen? Yes. Definitely going to take all of us unifying and aligning and doing this together to help all of society. Thank you all mental health professionals for doing your part in safeguarding people's mental health and protecting their human rights. We so appreciate you. Thank you so much, and have a wonderful rest of your weekend.
Thank you.
Bye.
Bye.
Bye-bye.